215 West 84th versus Bailey.
May it please the court, my name is Jeffrey Metz. I represent Adam Bailey and our law firm. I'm here this afternoon, Your Honors, asking you to modify the order of the trial court to grant the defendants legal fees and costs, as well as punitive damages under the anti-SLAPP statute.
So does plaintiff's action involve public petition and participation?
It absolutely does, Your Honor, and as a matter of fact, I think Judge Krause's opinion was well-reasoned, except when she got to the SLAPP, because she really relied on the outdated statute, not the statute that applies. Under 76A, an action involving public petition and participation is a communication in an open place, open to the public, or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech, et cetera, et cetera. Public interest is defined under the statute to be broadly construed and to be any subject other than a purely private matter. Now, this is not a purely private matter. If you look at the history here, there was a holdover proceeding that was brought. Our client files an ERAP application. It affects an automatic stay. Landlord was not happy with it.
What happened? Did your client get those funds?
The client was eventually turned down for the funds. However, at the time that this was pending, there was a motion made by the other side to vacate the stay, and that was denied because the housing court said that there was a colorable claim. So the landlord was stymied there. Now, the landlord did not take that up with the state that passed the emergency legislation. What the landlord did was, one, sue Mr. Azu for $85 million in a plenary action, in and of itself an extraordinary event. Also, very classic landlord harassing behavior, the mind-numbing noise right outside, the keyhole camera across, the debris falling down, the limited access, the elevators breaking down, and then when we get hired to represent Azu in the summary proceeding and in the plenary action, shortly thereafter, we're sued. Now, I don't know of any case where an attorney representing a client gets sued for that, and on the basis of an absolutely frivolous case. Abusive process was dismissed as a matter of law. Tortious interference with prospective economic interests, dismissed as a matter of law. Now, when we made our motion to dismiss, if there was some problem with their complaint, well, we know you can submit an affidavit to try and bolster up. They didn't do that. Instead, they completely pivoted to this absolutely phony claim that we told Azu to file the ERAP application. I can point you...
Didn't he file the ERAP before he retained you?
Yes, that's correct, Your Honor. 5 weeks before we were retained. So Azu said he submitted an affidavit. He said he did it himself. The landlord was aware of that because Azu submitted an affidavit in support of our motion to dismiss. Yet, landlord lied to the court below and said that we told him to do so. And
Well, hang on a second. And in fact, even if retained counsel were to give that, were to tell that to the client, that's part of the attorney-client relationship, right? I mean, it's advocacy in that sense, right?
Absolutely, Judge. Judge Krause said that even if we had advised him to do that, there's nothing untoward with that behavior.
I just want you to focus on why this isn't just a landlord-tenant dispute between
very
the
easy.
two, right?
It's easy because this case raises an important public policy issue, Your Honor. Attorneys have to be free to represent their clients zealously, free from knowing that they are going to get sued precisely because they're representing their clients. On the other, correspondingly, the client has to know that the attorney is not going to have a divided interest. Now, here we have a situation where, even though it was frivolous, until it's dismissed, it's still alive, and we're potentially subject to $25 million in liability. Now, we decided we're going to go full bore with this case because we thought that there was no merit to what was going on. So you've got this, look, when we go to law school, the first thing they teach you in law school is that you zealously represent your client. That's what we were doing, zealously representing our client. That is not actionable conduct. And if you
You know, the bottom line is, if we were to disagree with Supreme Court, that would be setting a new precedent in the sense that lawyers no longer have to worry about getting sued by their clients for legal malpractice. Now you're going to have to worry about being sued by the other side suing you for doing something that you shouldn't have done. So now you, as an attorney, you're going to have to call your legal malpractice carrier and say, oh, by the way, we now have a situation where I might get sued by somebody else now that I didn't represent.
Judge, look, you know, it's really, come on.
It's a can of worms that we're
Let's be
opening up.
straight about what happened here. This was all an intimidation tactic right from the get-go. As soon as the stay was in effect, he gets sued for $85 million. Then they sue us for an additional $25 million, all for one reason.
I'm looking at the big picture. I'm looking at the big picture in the sense that this loss, the record here indicates to me it's like this is really not a place where attorneys need to be in terms of having a concern in terms of representing clients. But you know, did you have a question, Counsel? Okay, thank you, Mr. Metz.
Thank you.
Good afternoon, Your Honors. May it please the Court, Y. David Scharf of Morrison Cohn for the respondent. Justice Krauss actually got it right.
Oh, okay, but would you agree that it was the old statute she used?
It was, but...
Well, let's talk about the new statute.
Yes, so both the new statute and the old statute and this Court's decision in Miller and Aristocrat say that we need to, in the first instance, have a matter that is of public petition or participation. And the analysis is not our complaint that we filed in court. The analysis is what was underlying, what was the conduct that we were complaining of. And there's this notion that we made a pivot. And I think it's important for us to recognize that there was absolutely no pivot whatsoever, because the two issues that we complained about was the filing of an ERAP petition, which is a private matter. The second thing was...
So you didn't accuse Bailey of a media smear campaign to get a large buyout, et cetera?
Yes, but if you...
So let's focus on that part.
But,
as an attorney, you think it's appropriate for the other side to sue the adversary because they're advising a tenant, whether it's misconceived or not, to hold out for a large buyout?
A lawyer is not immune from what every other person is out there. If somebody else is liable...
No, you cannot say a lawyer is any other person. Lawyers have a special place in terms of the legal community, right? And what really pushes me here is that you did not cross-appeal from Supreme Court's dismissal of your two causes of action.
Yeah,
That's very telling in a sense that, why didn't you, I mean, that to me would say that, no, we had meritorious claims, and we're going to press it on appeal.
Your Honors,
cross-appeal from
sometimes people can let it go, and sometimes people can't let it go.
Yeah, okay, letting go is fine, but counsel, the way I look at it is, and you heard me, I'm more concerned about the bigger picture, because now we're having a situation that's not only attorney. If we were to agree with you, we'd be opening up a new, I think, dimension in terms of attorney liability. It's no longer that they're going to get sued by their own clients for legal malpractice, but they have to also worry about the adversary suing them, saying that, you know, we don't believe what you did was proper. That's kind of...
Your Honor...
is that where we're going to head down if we were to...
Well, Your Honor is suggesting that lawyers get a free pass on and that there is no conduct that they can engage in that can't be tortious towards the opposing...
But it's not... Okay.
Wow, that is not even close to what we are saying.
Yeah.
What we are saying
Thank you.
is that I am sure you have taken aggressive stance. In fact, I know for a fact that you have, because
Don't
you
hold that against me, Your Honor.
Oh, no,
many,
both sides.
many times, You have taken aggressive stances on behalf of your client.
Never over the line, Judge.
There's no over the
I've
line.
never
Your claim was
I've never
dismissed.
stood in an advertisement, okay, with my book. Not that I've written a book, and had my.
Some of your briefs are Brooks, though, but okay.
Your claims were dismissed. Your
correct.
claim that that Bailey commenced a smear campaign, that was your whole tortious
but that's where you're
interference
wrong, Your
claim.
Honor, if I
That is a matter of public
You-
discussion and debate. Whether an attorney can zealously represent their client in real estate in New York City, which, as we all know, takes up a lot of airtime, a lot of
Hot topic.
news time, right?
Can we just look at the complaint, Your Honor, please? Because this really goes to the heart of it. Let's look at both causes of action. First cause of action, record page 29, abusive process, paragraph 50, which is first.
What process was issued?
I'm sorry?
What process was issued?
Yes.
What process?
Used judicial and administrative process of the state of New York, ERAP.
No, but the client said, he puts an affidavit in saying that the client himself put ERAP in before the representation.
Your Honor, but let's go back, okay? Because they put in an affidavit, but if we look at the time of the pleading, paragraph 31
I'm
upon
sorry,
information.
Mr. Scharf. I'm not buying that argument that application was processed in the sense of how we understand an abusive process claim in this state.
Your Honor,
Have you never told your client to take an aggressive notice to cure stance in a case that it was later dismissed as unwarranted? Of course you have.
Your Honor,
Of course you have. And so this lawyer telling his client to file for a government benefit that you don't think he deserves doesn't rise to abusive
that
process.
he's not entitled to, that
That he
everyone knows he's not entitled to, that every lawyer should know it's not an
So
entitlement.
every time your notice to cure is dismissed, that means that you're not entitled. You're not entitled. You're not entitled. Correct?
But that doesn't make the underlying frivolous. That doesn't make the fact that in the tortious interference claim was predicated.
Where was the evidence that the tenant interfered with the developer's contract rights to build the skyscraper that they claim this holdout tenant?
We're not talking
Isn't
about.
that tortious interference with contracts?
If somebody improperly acts with malice
No,
and.
but where is it on this record?
Sure, Your Honor. This is what I'm getting to, and I just want to, if I can reframe the question, because we're not talking about the tenant's conduct, we're talking about the law firm conduct. And the predicate is found at paragraph 61 on page 30 of the record. Defendant's wrongful and improper independent interference to the caused development was to unjustifiably and repeatedly demand the arrest of an agent when the agent.
I'm sorry to interrupt you, but doesn't that claim require interference with a third party? The tortious interference with economic, you're talking about economic advantage claim? That's what you're raising, right?
That's the economic advantage claim, yes.
Don't you have to allege that there was interference, Bailey interfered with third party, and that's the tortious interference?
Bailey
It's not a direct interference.
Bailey acted towards somebody who was on the property to interfere with our economic advantage. That party was there to.
What party?
The
Who did he interfere with?
non-party,
The managing agent, you're saying?
Yeah.
The managing agent?
The managing agent is
Yes.
on your side, though. That's not an economic.
Wasn't the managing agent found to be the person who summoned the police also? So factually, your predicate is incorrect.
No, because it doesn't matter who summoned the police. While the police was there, Bailey demanded his arrest repeatedly over and over again, which was improper because what he was trying to do was effectuate.
Well, it sounds to me that maybe the manager has some claim.
And they
False arrest, but even that didn't
and they make a big deal that he hasn't brought a claim, but he filed a complaint with the grievance committee.
Okay.
And therefore, there was interference, and we need to look at what the pleading is at the time.
If you were that strong on your position, you would have cross-appealed. You have not cross-appealed. I would suggest to you that the claims you raise are difficult claims.
Your Honor, the Miller case made clear that one can lose their underlying causes of action and still not violate the statute, and that's
That's under the old statute, though, right? Or under the
no,
new
no,
statute?
the
Under
Miller
new
case,
statute?
there were two cases, Miller and Aristocrat. I believe in Aristocrat, Justice Moulton was on, and Justice Oing, I believe.
Oops.
You were on the Miller case, and the Miller case specifically held that you can lose all of your causes of action, but still not be violative if it doesn't implicate a matter of public interest. This is a private battle.
But those two cases, correct me if I'm wrong, did not deal with attorneys on the other side.
Of course it didn't, but Your Honor, the conduct that we look at is not our lawsuit. It is the underlying conduct. It is the filing of the ERAP, which is private.
Okay.
It is the call. It is the assisting upon the arrest, which is private, and that does not implicate neither the new statute or the old statute, which is why Justice Krauss got it right when she said the predicate, and this goes to this court, which in the Aristocrat case, which they rely on, the court says the strategic lawsuits against public participation, that's the first thing, and then any communication in a place open to the public or public forum in connection with the public interest citing. And what we don't have here is an action by OZU or by the law firm that is in a public forum. It happens.
Was this not in the New York Times? Was this case not in the New York
But
Times?
that's not the standard. We didn't our predicate.
Wait a minute. Wait a minute. You're telling if the New York Times covers this, correct?
Yes.
And the issue is what attorneys can and can't do to zealously represent their clients. You're saying that neither one of those make this public.
Your Honor, the two actions that we complained about were not the New York Times. That was not the predicate of the abusive process. It was not the predicate for the tortious interference.
No. I'm talking about the anti-SLAPP section.
So allow me to get it out.
Yes.
Was it in the complaint that this was part of the scheme and this is what he did? The answer is absolutely not. But I would ask this court to take a look at it. But what Your Honor can't do, because this is really what happened, and what this court should not be doing, is send a message to lawyers to say the following two things. Number one, if you've got something sketchy that you're going to be going over the line, get it in the press, because once you get it in the press, you have this new protection that this court is going to carve out, because that's exactly what happened. Mr. Bailey.
Or maybe what we should be saying to lawyers is don't sue your adversary because they are zealously representing their client, just like you are zealously representing
Your Honor, I would
yours.
say if I stepped over the line, somebody should sue me,
Okay.
and somebody should sue Adam Lightman
let's-
Bailey for stepping over the line.
Let's not do invitations there. Thank you, Mr. Schaaf. I got it. We got it. Thank
We're going to
you.
make it about me, you know, I
got it.
recognize what we're talking about.
We got it. Thank you.
It's not about you. It's about lawyers, right?
I agree.
Okay, we're not back at the trial level, guys. Okay. So just to be clear, I mean, we're on equal side, you advocate very strongly, like Mr. Schaaf, your clients too. And I've been downtown where you've got the sharp
I have
elbows
no
too
issue
on
with
both
his
sides.
zealous representation. I just think that
I
he's
just wanted to
wrong.
make sure
I
that we're not.
want you to address really,
I
I'm
just
sorry.
want to make sure that we're not just beating up
Right.
Mr. Schaaf. You equally have that kind of reputation. Thank you.
But I think the best argument that I heard was that it's a purely private matter. So tell me why that's incorrect.
Sure. There's two reasons. Number one, let's just get to the base part of this. This is landlord harassment of a tenant. That's what this is. There is a direct statute, 235D of the real property law, says you cannot harass tenants by doing exactly what the landlord did in this building. I urge you to...
No, but why is that public? Why, I mean, that happens
Well,
every day in landlord-tenant court. One or the other says, we don't have anti-slaps and all those.
That may be so, Judge. That may be so. But it doesn't morph itself into a lawsuit against the attorney who's representing the client against a very well-heeled adversary who would not take no for an answer. His problem was with the legislature, and I would like to point that to you, Your Honors.
No, I'm just, again, why is this not a
Because
private
it's
dispute
because-
between a
because-
landlord and tenant that
because-
happens every day in New York City?
Judge, it's a fundamental chilling of the right to represent your client. And even talking about any kind of media exposure, that's part of the lawyer's toolbox. You can win a case not in court. There are other ways to win the case. So if Mr. Bailey, first of all, Azu said in his affidavit, and it's uncontroverted, he said that he invited the Times to his apartment, not Bailey. That's what he said. That is uncontroverted in this record. And again, I really take umbrage at my adversary going over this complaint. It was dismissed. It was dismissed. He filed a notice of appeal. He withdrew the appeal with prejudice. So any arguments about his complaint is gone. And if you want to look at the complaint, it was all dealing with this so-called media and his so-called managing agent, and somehow that affected a tortious interference with economic prospect. And
It was a private matter until this lawsuit got started, right? I mean, that's essentially
started
it.
off as a private matter, yes, but
Right.
you've gone.
Well, what I'm saying that
You
you didn't elevate it to more than what it was until this lawsuit got started. Like,
Well, Judge, look, you might say that his suit against Azu was a private matter. He said there was a breach of contract, but not against Bailey. That's a different animal altogether, because now you're implicating the right to defend your client. That's what's going on, and he wants to chill this. He wanted to intimidate us to give up our client, so the client would leave before there was any adjudication of the holdover proceeding. That's what was going on here. It's so obvious. You cannot ignore the fact of what happened here. Nobody sues the tenant for $85 million when there's a stay in effect, and then sues the attorney a month later for another $25 million.
okay, thank you, Mr. Metz. Thank you both.
Judge.
Good seeing you guys.